Hi, good morning to all. If you are not subscribed to the channel, subscribe to the channel. Now let us come to a very important judgment which is pronounced by the Gujarat High Court. Here, let us first understand the facts of the case. The facts of the case is that the department has issued notices to various traders asking them that the input tax credit claimed by them is not eligible as the suppliers has not deposited the tax with the government, and I have asked them to reverse the ITC with interest and penalty. The traders have approached the Gujarat High Court and made an application stating that the section 16 subsection 2 class C, the input tax credit on the actual payment of the tax by the supplier to the government should be struck down and should be declared as unconstitutional. The appellant's argument, that is, the traders or the purchasers' argument, is that why it is unconstitutional arbitrary, violates the Article 14, 19 of the Constitution, fails the proportionality test, the supplier's default is beyond the control of them. Once they make the payment to the supplier, they have no control over whether the supplier has deposited ITC to the government or not, whether the tax is deposited or not. It is beyond the control of the purchaser to ensure that the tax is deposited by the supplier. Hence, its doctrine of lex non cogit ad impossible. When it is impossible to do something, the law cannot expect it to be done. Hence, on the ground to be stuck, this section 16, subsection 2, class C leads to double taxation, cascading effects where the tax is paid to the supplier and denied credit does not differentiate genuine from the fraudulent transactions. What was the respondent's argument? That is the department argument. ITC is a concession, not an absolute right, privilege granted by the statute subject to strict conditions and restrictions. Projects government revenue essential to ensure integrity of the tax chain, maintain fiscal balance between the originating and destination states. The scheme provides recourse. Section 41, subsection 2 and Rule 37A allows for reversal and re-availment of ITC once the supplier deposits the tax. Burden of proof lies on the claimant. Section 155. Court conclusion. The constitutional validity upheld. The court refused to declare the Section 16, subsection 2, Class C ultra virus or read it down, challenges dismissed. The adherence to the condition required. All the conditions or the Section 16, subsection 2 are congeniate. ITC is not an absolute right. Scheme balances revenue interest. Government re-evaluation. Government should look into elevating the hardship for the genuine purchasers through better tracking and expediting recovery. It's a very important judgment as if you are not able to maintain proper documentation, then you will be stuck in a very bitter legal battle and you may lose the input tax rate along with interest and penalty. Hence, you have to ensure that all the documents which are required for the movement of the goods, like e-way bill, the lorry receipt, the payment to the supplier, etc., should be properly tagged and kept. If any dispute arises in future, you should be able to produce all these documents and also ensure that you do businesses with the reputed suppliers who have a very good track record so that you do not face this type of issues. Thank you and subscribe to the channel if you like it.